Hey everybody, I'm hoping you'll enjoy the lecture that we have today. It's going to be, I think, a little bit fun, and because of that, I've got my favorite correctional facility behind me. This is the Hickman, Kentucky City Jail, established in 1914. My mom and dad were both residents, citizens of Hickman, grew up in Hickman. I'm not going to tell you what connection my dad and his dad may or may not have had with the Hickman City Jail, but let's just say that I've heard some stories. And I hope that someday you may think back about your old business law professor fondly and be looking and run across maybe a collection of some stories that I've written about my dad and his experiences in growing up as a young boy and young adult in Hickman, Kentucky. Um, I think Huckleberry Finn just a little worse, maybe. I don't know, but in any event, hopefully you'll enjoy it. And that's about it for that. But I think you'll enjoy today's lecture too. Today's lecture, I think, is. Let me go ahead and share my screen on this. And let's see, I think this is screen two. Hopefully that's the right. Nope, that's the wrong one. Screen one is the one that I need. Okay. Hopefully that has what it's supposed to have, which is business entity war stories. Lessons for small enterprises. So this is, I think, a good place for this topic. The small business enterprises is a little bit shorter section than some of our others, a little less material, and this kind of weaves in um, both corporations and small business enterprises and talks about some things that maybe went wrong with some specific things. And when I say war stories, uh, lawyers use this all the time. So I probably should tell you this has nothing to do with war. I apologize if that. It's just basically, our experience in working every day as a lawyer and kind of some battles or whatever that we have as lawyers or problems and that kind of thing. It's just basically our experiences. Lessons for small enterprises, choosing and managing the right business entity, focusing on the different entities that we focused on, and learning from real world experiences that the structure matters. Dolly's Donuts. Dolly's Donuts. And I will say here that the names have been changed to protect the innocent. These all represent real life stories, but I did change it enough so that hopefully none of them are recognizable from the actual ones that occurred. I might have clients that get irritated with me if I don't. Dolly's Donuts. I had a client that he himself sued Dolly's Donuts. He was very proud of himself, sued in small claims court and got a $5,000 judgment against Dolly's Donuts. Be careful with that. Be careful. Let's think about that. Dolly's Donuts. What's wrong with that? Well, what was the legal entity? Was it a corporation? Was it Dolly's Donuts Incorporated? Was it Dolly's Donuts Corporation? Was it Dolly Madison Corporation doing business as Dolly's Donuts? Was it a limited liability company? Was it a limited partnership, individual? Was Dolly Madison just running it herself as Dolly's Donuts? Who was it? You know what? It matters. The result was my client had an uncollectible judgment. You can't just, what's Dolly's Donuts? What is Dolly's Donuts? We need to know what it is. You have to sue the right entity. Even if it's an individual doing business as Dolly's Donuts as a sole proprietorship, you have to sue, in that case, the individual, Dolly Madison or whoever Dolly was. You have to sue the right company. That's what went wrong. You can check the Alabama Secretary of State website. They have a business entities search function and documents. In this case, it involved a contract of some sort between my client and Dolly's Donuts. Well, the contract itself had the right name on it, but he didn't sue the right name. Secretary of State will also have who the registered agent for service of process is. When you form a business online, when you form a business by filing paperwork, whether it's a corporation, a limited liability company, a limited partnership, whatever that requires filing with the Secretary of State, you're required to include a registered agent for service of process. Service of process means who you actually serve the lawsuit with. And they tell you that. And had he checked this, he could have gotten the name, the registered agent, everything would have been done right. He would have had a judgment that was collectible. As it was, Dolly's Donuts, there's a judgment against Dolly's Donuts for $5,000, but there is no, that's a fictitious entity. There's no legal entity by that. These things matter. Sub S Corporation got torpedoed. I amuse myself with these headlines. I hope that you will enjoy that. Sub, like submarine, gets torpedoed. Oh, well. I think it's funny. Corporation, in this case, was correctly formed by 3 equal shareholders, did everything right when they did it. Not only that, they filed a tax election for the S Corporation correctly, timely, correctly, everything cooking along just fine. Not only that, the business did well, and it did well for years. It was just making profits and making profits and making profits. Well, one of the shareholders did so well that he decided it was time to get out, go enjoy the good life. He sold it to a relative, a younger relative who happened to be a resident citizen of Paris, France. You should be thinking right now, what has gone wrong in this war story? Well, here's what happened. When you transferred your shares to a non-US citizen, you terminated the subchapter S election. Why? Because only US citizens and certain trusts can be a shareholder of a subchapter S corporation. They messed that up. What kind of consequences does that have? Major consequences, major adverse tax consequences. In this case, and not, you don't have to know all of this, but in this case, it involved a construction company that had a particular type of installment type contracts where they were able to recognize income over a period of years. Like, they have a $2 million contract and they would have to recognize that $2 million of revenue, but they'd have to recognize, or they would be allowed to recognize it not in year one, but over year 1, 2, 3, 4, and 5. Well, what happened was when they made the transfer from the qualified shareholder to the non-qualified shareholder and terminated the election, it artificially made the corporation a C corporation because the S election was terminated, and it artificially accelerated all that income from all those contracts into the present year. Why? Because C corporations could not take advantage of that particular tax installment type provision that an S corporation could. Major, major problem. But you guaranteed, key on that word, you guaranteed an LLC would protect me. Well, let's talk. Business formed an LLC properly. Did an LLC company agreement, used to be called an operating agreement, it's now called a company agreement. Got their tax ID number by filing that form SS4, set up their bank account, Bank was happy. They had all the right paperwork. They had the company agreement. They had the tax ID number. They had an LLC resolution from the members that managed it. Everything was cool. The business did the right thing. They paid business debts out of the business bank account. They took business revenue and put it in the business bank account. They respected corporate and limited liability company formalities like they were supposed to. So what went wrong? Well, in connection with the business, they had signed a 5-year lease for the business under the LLC name, which they should have, and a personal guarantee from the owner. The company, even though they were doing the right things, the business wasn't the greatest business model, and they went under 18 months after formation. Lost money, just couldn't turn a profit, never going to turn a profit. 18 months in, went under. My client was prepared and ready to lose what he had invested in the business. That's what happens when you have an LLC or limited protection type company, S corporation, C corporation, something like that, right? You lose what you've invested, but nothing else. Well, this 5-year lease still had 3.5 years left to go on it, right? What happens to this 3.5 years lease? Well, the landlord, the owner, sued the owner personally. The owner of the property sued the owner of the LLC personally. He got personally sued. Why? You guaranteed an LLC would protect me. Well, it does. The LLC protects you, gives you, the individual owner, personal liability protection, but against entity debts. Well, wait a minute. Wasn't this lease an entity debt? It was, but the personal guarantee is not. The personal guarantee is an individual debt. It's something you did on top of it. Now, does that matter? Well, as a practical matter, try going to the bank with a limited liability company or an S corporation, a small business, and borrowing money and try doing it just in the name of the business. You're not going to be able to. The bank's going to require that personal guarantee. Commercial leases, try doing that just in the name of the business. Try doing that with just that and no personal guarantee. You won't be able to. That's just the way it works. But at least you know that going in, and maybe you can negotiate it. I have negotiated before partial personal guarantees where the individual personally guaranteed, 3 years of a 5-year lease. They guaranteed 50% of the lease payments, something like that. Sometimes you can work with it, sometimes you can't, but at least you know that going in. A guarantee is only as good as the entity itself. In this case, it was a personal debt because he signed a personal guarantee. We skated by doing the minimum and we got skinned. Again, I'm amusing myself. I had clients that formed an LLC online. As I said, it is super easy to do. You can go online to the Alabama Secretary of State website. You can fill out a form online, a certificate of formation. You pay your fee. I think it's $236. I did one last week, so I'll remember that, shouldn't I? And you're formed. That forms it. Now, what else should you do? Well, a bunch of other things. You should do an LLC company agreement. You should have the resolutions. You should have the company agreement should address certain things. You need to get an SS4, get a tax ID number. You need to get a bank account. You get it. Well, in this case, my clients formed a skate park business. Get it? We skated by doing the minimum. And it failed. And the property owner, they leased property and poured concrete and built a skate park. The property owner that leased them the property and customers who were injured sued my clients individually. But we had an LLC. Well, you had an LLC, but you didn't do any other paperwork. There was no company agreement, no tax ID number, no bank account. As a result, whoops, sorry, corporate formalities were not followed. Piercing the corporate veil took place. Corporate, wait a minute, didn't you say it was an LLC? Well, piercing the corporate veil, respecting corporate formalities applies not only to a corporation, but also to LLCs and other limited liability protection type entities. The same kind of judicial doctrine applies to that. You've got to respect it. Basically, the law is like this. Look, if you're not going to treat it like a real live separate entity, why should we have to treat you like that as well? And the answer is we don't. If you don't respect yourself as a LLC, we don't have to either. We can sue you individually, and they did. You have the right to remain silent, but not the ability. If you're a Ron White comedian fan, you'll understand that. He's got a nice little funny skit with that. Now, I'm not telling you that you got to like Ron White, because he can get a little risque in his comedy, but that little bit that he does, I think, is very, very funny. Right to remain silent, but not the ability. Doctor, love doctors as clients. They are the best medical professionals and the worst business people, requiring the most legal attention that you can have. Bless their hearts, as my mom might have said. Dr. Klein invested $100,000 as a silent partner in a friend's restaurant business. It was a handshake deal. There was no paperwork done or whatever. Doctor thought, I'm a silent partner, I'm a limited partner in this. The friend's doing everything else. And he knew enough that limited partners have liability protection and general partners don't. He knew that. So, I'm a silent partner, whatever. Well, the restaurant unfortunately failed. Some restaurants do great right off the get-go, right off the bat. Some of them don't. In this case, the restaurant didn't. And they also had a customer who had been injured on some loose steps there at the stoop of the building, actually inside the building. It was kind of a weird kind of thing, which was a problem because my client installed that. And the customer sued them, and the landlord sued them. So they got sued in both situations. Well, they got sued individually. The doctor thought, wait a minute, I'm a limited partner. I'm okay. Now, I'm not happy about losing my $100,000, but heck, I'm a rich doctor. I can afford to lose $100,000. Well, what happened here was, oops, you're not a limited partner there, boss man. You didn't file anything with the state. You've got to specially file things with the state to be a limited partnership. You got to file something to be a subchapter S corporation or C corporation. You got to file something to be a limited liability company. You can't just say you are. You got to do something. So what if you're not a limited partnership? What are you? Well, I've told you before in the materials, the easiest way to do business is as a sole proprietorship. And the next easiest, which is almost the same, is as a general partnership. Two guys just shake their hands and say, we're going to go forward and do this. We're a general partnership. That's, whether they say they are or not, they are. That's what it is. Here's what happened. Not only was the doctor wrong that he could lose more than his $100,000, he could be personally sued. Let's say that it was a $500,000 judgment that was against the partnership. He could be personally sued, not just for his $100,000, not just for half of the $500,000, but for all of it, because they are jointly and severally liable. What jointly and severally liable means is this. It just means that partners, each of them, they jointly together are responsible for the debts of the partnership, and they are also severally, meaning individually, liable. So it means doctor is responsible for the entire $500,000. His friends are responsible for the entire $500,000. whoever the injured party is that has the judgment against them can collect against either one of them. Well, guess what? Doctor's the only one that's got money. Restaurant guy, he was a chef. He thought he'd be able to run the business. He didn't have any money. That's why he needed the 100,000 from the doctor. So they go collect from the doctor. Now the doctor has something called a right of contribution, where if he pays 500,000, he can go after his friend for the other 250,000. But the friend didn't have any money. So there you go. So not only was it 100, not only was it 250, it was a $500,000 mistake with that. Hey, don't jam me up, man. I know I'm using only myself with this. People are suckers for these homemade foods and homemade this and that, whatever, at flea markets and antique shows and pepper farm, all that kind of stuff, right? Well, I had a client that sold these homemade jams for 15 bucks a jar, called it Jill's Jams. And Jill's Jams are doing great. I mean, they were selling 100 jars a weekend for 30 weeks out of the year. That's 1,500 bucks a weekend. I mean, that ain't bad for a side job, right? Well, until they had a bad batch. And I don't know what they had in it. It wasn't jams, actually. I'm just making up the thing, but it was something else. And people got food poisoning. They sued Jill. Again, they're doing business as Jill's Jams. She's the sole proprietor. As the sole proprietor, she's liable for the whole shebang. Booyah. Unfortunately, these judgments against her were against her and not the corporation. They weren't against Jill's Jams Incorporated because there was no Jill's Jams Incorporated. It wasn't against Jill's Jams LLC because there was no Jill's Jams LLC. As a result, she's individually liable as a sole proprietor. Her bank account got seized. Her wages from her day job got garnished. It's a bad situation all around. Anyway, I've seen 10 gazillion of these things over my time because I'm old and have done these things for a long time. But I just thought these 5 or 6 stories might help illustrate what we're doing and kind of bring some reality to the situation. As I said, they're all real situations. The names have all been changed to protect the innocent, if you will, but they've all been there, done that. Uh, anyway, hope this helps, and I will see y'all next time.